In the judge's instructions, he says, I don't want you discussing what you couldn't discuss with him if he was on the stand in front of the jury. What's wrong with that?
Because if he was on the stand in front of the jury, they wouldn't be allowed to discuss.
No, he's saying, I don't want you discussing anything that you couldn't discuss involving his testimony before the jury. That's the standard for what's permitted and not permitted at that evening.
Okay, well, the trial court, if you read the entirety of the colloquy between the trial court and defense counsel, it's clear enough that the trial court prohibited all discussion of testimony, the defendant's testimony, during the overnight recess, and that is how the Texas Court of Criminal Appeals interpreted it. So the Court of Criminal Appeals interpreted I'm going to get the wording exactly right from the court's opinion. The Court of Criminal Appeals said, they described the question presented as, does a trial judge's sua sponte order that defense counsel could confer with defendant on everything except his ongoing testimony violate the defendant's Sixth Amendment?
So would it violate the defendant's Sixth Amendment right to counsel if during trial he was precluded from being coached or managed by his attorney?
You mean during an overnight recess?
No, during trial.
Oh, during trial. No,
What's
during
the
trial.
difference?
Under Perry, well, Perry drew a sharp line between overnight recesses and brief daytime recesses. And the court said that during a brief daytime recess, like I think you're talking about here.
No, what I'm talking about is, why is the standard different between what a lawyer can coach or manage with respect to testimony while he's on the stand, which is basically a concern, and what he can coach or manage during the recess?
No, it's the same. The distinction, let's be clear about the distinction between impermissible coaching and legitimate necessary counseling, right? Because that's a sharp line, and in answer to your question, that line is the same at all times during the proceeding. That is, whatever is impermissible before trial begins is also impermissible during an overnight recess. It's impermissible at any time, and let's talk about what that difference is, right? So the impermissible coaching is where the lawyer tries to get a witness, the defendant or any other witness, to testify, where the lawyer tries to change the substance of the witness's testimony, to try to get the witness to testify to something other than that which the witness believes to be true. But contrast that with conventional counseling, which is talking about the testimony in all other contexts. So, for example, advising how to comply with evidentiary rulings, even rehearsing the questions and answers.
But did any of that happen here? Do we have evidence that any of that happened?
It couldn't have happened. It didn't happen because the trial court barred the defense counsel from discussing Mr. Villarreal's testimony with him during the overnight recess.